try to move the microphone for the Q&A stage. Okay, thank you all for very interesting presentations, which each was in a quite a different matter, but they all interacted with each other, and I think it was really nice. And now we will open the stage for questions, for discussion. Yes.
My question is to Anat. Well, it doesn't lie with you.
Please
Present yourself, please. Yes.
I'm Berg, University of Edinburgh. My question doesn't lie within the issue of looting and other war crimes. It lies within the stated topic for the formation of the structure of Israeli armed forces. So it's just interesting to me which country's armed forces structure was the most influential in creation, in the formation of the Israeli armed forces.
Okay. And you want me to answer now?
Yes, please.
Okay. So, thank you for your question. The most influential, well, the IDF is based on the British military, but it combined. Well, I know both. I'll talk about the legal system, but also in every aspect. It absorbed the militia that was created here, and there's actually the absorbance it comes in of the British structure comes in two phases. The first one was when veterans of the First World War, who were Jews who joined the British military in the First World War, came back to Palestine, and then they started this militia. So they accepted all kinds of aspects into the system. So, like the entire legal system is based on the British system since the end of the First World War. Then the Second World War, again, Jews from Palestine joined the British military, and then of course you have to take into consideration the mandate here. So it's British, but it is also it absorbed both the militia and the. So there are certain aspects, like the fighting brigades are based on what was created here, but other like professional branches like Air Force and communications and artillery are based are more professional and more British. So okay.
Thank you.
Yes, I'm Minale and I teach Roman law in Italy. I have not a question maybe, but a suggestion to make about the very interesting contribution of the colleague Anat.
Okay.
Many scholars has made, and especially coming from the French historiography, has made an interesting confrontation between the Tzahal and the Roman army, the army during the Roman Empire, the Roman period. I think it is not a confrontation about the value of invincibility of the Israeli army and the Roman army, because the Israeli army has suffered some was defeated in the history, and Roman army was terribly sometimes defeated during the centuries. I think the confrontation is especially about this period, about the period of the birth and the transformation, the birth of the army and the transformation of the army during the birth of the state. There is a very, very strong ideological background under this, how can I say, this history of 1948, and under the Roman history, especially during the Republic and during the time of the war against Hannibal. It is not maybe could seem as a specific thing. It is not so specific, because during the Hannibalian wars, Rome was totally defeated, was totally in crisis, and was necessary to how can I say, to make another army and to create another army with other structures and so on. And it was very impressive to see that one of the most important problems in that time, during the Hannibalian wars, was the attempt of the consuls, of the generals, to order to the soldiers to not to keep the Goths abandoned by the population, not to steal, not to rob. The Goths abandoned by the populations belonging to the cities which has chosen to make alliance with Hannibal. So the importance was to present Rome as the bringer of a new order, of a new justice. So I think the ideological background is in this kind of histories. Of course, there are many of these histories in history. I teach Roman law, so I think about Roman army. But the confrontation is not with the imperial army, with the machine of death, with the structure of conquest, and no. In fact, the EDF is really defense force. And in that time, the problem was to defense Rome, to survive. So I was very impressive because in this way the confrontation is possible.
Yeah.
So, thank you.
Wow, thank you. I think there are so many differences, but I think what strikes you is the attempt of a fighting force to try to keep a moral code that is connected to the honor, the ethos, or the honor of that force. So I think that was very vivid in the Roman army, and I think also in the IDF. So yeah, thank you very much for that comment. Very interesting.
I have a question for you also. I wanted to know.
Who are you?
My name is Van, and I'm a PhD student in history here at Tel Aviv University. I was wondering about the honor code. How do you perceive it? Like, if you perceive it as an honor code towards the Arabs that are being looted, or towards themselves as Jews?
It's not politically correct to say, but I think it was the. Let me just say a general. If there was someone who would be arguing the Palestinian point of view towards my research, then they will say that Israel has looted and it has taken everything, and every Tel Aviv campus, and the land and all that. So my research is focused on how the IDF perceives itself and how it tries to control its men. So the honor is a Jewish warrior, right? This is part of Zionism, part of the development of the new Jew. So this is immoral to steal. So this is why, the Hebrew soldier, that quote that I gave. So yeah, it's not about the Arabs, it's about the Jews and about the honor of the IDF.
I may add some point to both of you regarding that issue, if I may. And we have time, nobody wants to ask about black market, so I'll add a few notes about it. I think what is the main issue is the modern army became a professional army, and then it's based on discipline. And when you have discipline, you need discipline. Then looting or other acts like that, not just it harms the enemy, nobody cares about it, but it harms the discipline that you must obtain in order to control your troops. So I think that's the main point regarding looting and homicide and things like that, because you might act violently, very violently and brutal, but only by order and not by something like that.
Also, if you loot, you can't fight. So
Oh, you can.
Yes, but at the beginning was the Israeli army was not a professional one, and also during the war against
that's a
Hannibal
change.
was not a professional. The Roman army was made by citizens. And every Roman citizen must to buy.
And I think that's exactly the
must to buy
point.
the sword, must to buy the horse.
I think that's exactly the point. The shift between
The passage, I can say, the transformation between
exactly
the
civil
Yeah.
citizens army
and this is very, very
and a
very,
professional one.
Oh, I've got another question. I will present myself to Gal. Gal or Gal?
Gal.
This time. So I just don't know anything about it, but just my wild guess. My guess is that about why did Israel why didn't Israeli introduce civil marriage back then when it just was created recently? Was it because the founding fathers of Israel were ideologically left-wing, so they believed that marriage itself was sort of an anachronism of the past and it was to die out, something like Bolsheviks thought in the Russian Revolution in 1970. Am I right or not?
In 1953, when the rabbinical court's law was enacted, Israel's government was not at all leftist. It was a coalition of, let's say, left-leaning center Mapai and religious parties. Now, the actual leftist revolutionary Achdut Avoda, which is a social party leaning to the communism at the time, was left outside those first coalition governments. So you may say that the rationale for keeping the arrangement is a religious one, but I don't believe that. Also, I think that it is much easier to rule a state in which people are divided into 14 religious sects that are each one enclosed in its own cubicle and not allowed to step outside of it, rather than something in which one's identity is more fluid. Okay? Sorry? Yes, exactly. Divide and conquer.
Was this division of the religious communities in the 14 was any related to the Lebanese solution, which is still administration is still done to some extent according to religious communities?
The sources of both the Lebanese arrangement and the Israeli arrangements are very similar. They both come from Ottoman rule. The system is called the millet system. Millet is a religious community in Turkish. Yet there is a very wide difference, yes, between Israel and Lebanon, because Lebanon is a constitutional democracy, a democracy in which those differences play an explicit role. They say that the president must be a Maronic, the vice president is Shiite, and the chairman of the house is Sunni. We don't have this here. We have those differences only in the field of family law, but it actually, by determining one's identity, and this being a Jewish state, this means as much as it does in Lebanon.
There's a question from me.
I have a question about Noya, about the legislation. I don't quite familiar with Israel's legal system and history, and I'm very interested about the legal system. I have heard the Israel legal system is a mixed legal system. It's also influenced by the common law tradition. I'd like to know, at the very foundation of the state of Israel, the legislation, the action of the legislation is to cut off the previous case law tradition, or there is any competition between the case law and the the code law in the Israel.
סעיף 11. כן.
So, if I understand your question correctly, it's a completely different matter from legislation. We have a judiciary common law system where the judiciary has legally binding decisions. According to that, the judiciary decisions evolve. The judiciary can annul acts of legislation enacted by parliament. And everything basically withdrew its characteristics from the British system: the army, the judiciary, the executive, the relation of powers with the legislator. Is there anything? Did you mean anything specific you'd like me to answer?
Regarding Jewish?
In what way?
The Jewish religion, the religious law?
It's not the religious law. I mean the source of law in general.
According to Article 11 of חוק יסודות המשפט, it's like it's an act that says in a case of lacuna how the judiciary should decide. So basically, theoretically, according to the law, the judiciary should decide according to the Jewish legacy of the legacy of the Jewish people. It doesn't really work that way in the Supreme Court of Israel, and even in a very clear way, Chief Justice Aaron Barak declared that before he turns to Jewish sources, he goes to declarations of independence, of human rights. So it's a more matter of formality.
Can I add something there? I think what's common for all the papers that we're giving here today, that in this panel, and this is the organizing committee, I think this is your trick, yeah. That there is a continuation. Like, you would expect that once Israel is proclaimed on May 14th, 1948, that the earth is going to move and the sky is going to, I don't know, whatever, and everything is going to change because there's a sovereign state. But in fact, you can see that in religious law, legislation, economy, and the military, which is, of course, during everything is happening in the midst of a war, nothing changes. So this is Nimrod's title, right? There's a continuation. It's not a turning point. It's supposed to be a turning point because the framework is changing. But in fact, what happens is that this society, this community, the Jewish community, is just keeping, it takes time till you are able to shift like this big ship, right? So people, what they do is, like in my case, they don't have the law, so they use the custom law, and what custom law says is what they do. They don't. So they say, I don't know, I haven't heard, there's no law. They're just, there is a law, but they just don't use it because people do what they do. It takes a little bit of time until things change, and I think it's really nice that it's institutionally it's still like that, right?
Yeah. Some of our laws are still British mandate orders.
Yeah.
Any more questions? I'll take the mic. I actually have questions for all of you, but Anat, you just answered my question for you, so I'll skip you. I'll start with Nimrod. Your conclusion is very jurisprudential. I mean, how people conceive the law, or why people obey the law. And you say, with regard to the black market, that they obey the law as long as the law is good for them. So did you, or you researched the black market, but can you say the same thing about other areas with regard to the relation of people, of the citizens, so, in general, and in the formative years in particular, towards the law? I will ask my questions and then I'll give you the microphone. For Noah, two quick questions with regard to the role of the Ministry of Justice at the formative years. they did not just advise the government. They initiated bills. They researched. They had a very major and substantial role in the formation of legislation at the beginning of statehood, and they still do. I mean, it's really amazing. I mean, all the idea of the separation of authorities. It's very fluid here. I don't know, again, about other legal systems, but in Israel it's very fluid. But I think that today, I would say the last 5 to 10 years, more and more private bills are turning into laws. I mean, they do have to go through this governmental committee, I agree. But Anat Maor did her research, I think, until the 90s, and then she showed really that only a minority of laws are initiated by opposition members of the parliament. But today it's shifting. So I wanted to know if you have any explanation for that. And for Gal, I actually have a reply to Martin, right? Yeah. Lee? Ilya, I'm sorry. Okay, if I had another week, maybe I could have learned all your names. So in 1953, when the rabbinical courts law was enacted, one of the arguments that is made in the Israeli literature about it is that the secular liberal parties, or you can say men, supported this kind of law because for two reasons. First of all, it maintained the patriarchal power, because according to religious law, or within the religious procedures, men have extreme power over women, in comparison to women. This is one, and second, they saw the Judaism, or the Jewish religion, not just as a religion but also as a national identity. So they took upon themselves this religious system or the jurisdiction, so to maintain the Hebrew Jewish majority in Israel. So this is the one. So following this, I have a question for Gal. So it was very apparent that it was very ideological in 1953, but for many years it was. I mean, there was still this option. The 65A was still intact, and there could have been an option, but then to establish a civil marriage, but then it was eliminated. Was this elimination accompanied with the same ideological discourse, or was it just vanished? That's it.
Thank you very much for your interesting question. So basically, the question is regarding the title law as recommendation only, and if there are any more fields that we can see that point. So I start with a positive attitude. As I mentioned, and I will mark it, the security, for example, was not something that considered as a recommendation, because here life depends on it. So, for example, traitors were acted very harsh. All the question of recruiting to the army, again, at 48 it started, and people had to, actually the government forced people, and then it became something quite clear, that there are no games in that field. But that's on the positive way. The other way, meaning that people really consider it as only recommendation, or something that you do if it fits you, no more than this. It's mainly in the economic fields, and there you can find so many different examples. For example, all what we can see in Lichovsky studies, the tax system. So within the tax system, people always look for their way to solve things, including hiding income, and so on, and it took years to shape certain kind of normality, and I'm talking about decades, up to the 90s, I guess, more or less. It goes on to customs, to almost any economical field that you might think about. It also goes, but also to other things that it's not, it seems at the beginning not so crucial. For example, all the issue of traffic, of how to drive, how to respond to the rules, whether it's something that you must obey or it's only something that you do by force with the police and so. And I think it's something that goes on till nowadays, that the law is not considered like in other places as something that you must obey in order to gain order in the society, but something that if it fits you, then go with it.
Interesting. Thank you. Me first.
That's what you do. That's what you get when you get historians to speak. You get more than one historian in a panel, so there's
Okay,
no need
so-
for the law.
Yeah, first of all, you're correct in both your remarks. The Ministry of Justice not only puts the bill into the right legal format, it initiates bill, and it can basically be described as a bulldozer pushing towards approving governmental legislation. As for more private bills being approved today, you are also correct, but we need to look at the numbers first. In the 18th Knesset, which is the first Knesset that we have electronic data on, out of 4,614 private bills, about 240 were approved. So the percentage of private bills being approved is about 5%, which is very low. But what is more interesting, I think, is the content of the bills. Okay, so while the government initiates very comprehensive bills, such as Chok Esderim, which is a law that basically deals with every possible subject each budgetary year, private member bills deal with very specific subjects, such as wearing a helmet, such as parking on Saturday, such as whatever you can think of. Out of 4,600 bills, there's a bill on everything. Okay, but I have to say that some private bills are very important. For instance, Chok Mishal Am, an act that originated in a private bill that deals with referendums, okay? The new העלאת אחוז החסימה, okay? The number of votes you need to have in order to get seats in the Israeli parliament also originated in a private bill. So I think basically private bills are meaningless unless it comes to very specific bills where they usually originate in the coalition, if not in the government, so they have governmental support, and we're talking about very specific cases.
Gail asked me how the Article 65A was finally abolished. I found out it was a kind of a hoax. The law was a part of Archaic Laws Cancellation Act 1984, in which hundreds of Ottoman and British laws were cancelled as being archaic. The bill, in the part relating to Article 65A, stated that Article 65A gives the power to make law provisions for the divorce of foreign nationals. This provision is superfluous since independence. This is an outright lie. Now, none of the Knesset members checked it. All of them voted. There was no discussion in the Knesset protocol, and so it's gone. If it were here today, I believe it might have been used. It could have not been used, but the structures that are trying to build today, named Brit HaZugiyut, Pact of Intimate Partnership, a law that was enacted, and other private and governmental bill are much less powerful than Article 65A that was thus abolished. Thank you.
Thank you all. It's very interesting.